Welcome again. We're going to begin already. In order we are okay with the time. I'm going to introduce the first panel of the last session of the conference. It's called Technology for Providing Reliable Services. The moderator is Vito Janella. I think Vito is known for every one of us. He has been involved in this world, international scope of business register for 20 years? Don't say too much, okay. Well, he has a degree of telecommunication engineering for the Sapienza Università de Roma. He is in this moment consultant for EU advice in London and Brussels. He is currently member of board of ECRF, currently member of the CLEC Company Law Expert Group in the European Commission, and currently member on the online dispute resolution. He also has been the founder and of EBR, and also has been in the board member. And well, we can say that Vito is like the father of the creature in EBR. That is more or less the beginning of interconnection of business registers. Also, he works for Italian Business Register for International Affairs Relations. And he's also a member of the ECRF Steering Committee. And, well, he's really an institution in this world. So I introduce Vito. Thank you very much, Vito.
Okay. Grazie, Andres. Very. Okay, let's move to the content now. What we are going to talk this morning with the 5 speakers is about technology, how the technology has been able to support the business register activities, to transform the business register activity and enhance the services provided by the business registers. We will discuss also about the standard, how the standard can really contribute to the performance, the quality of the services provided and the data provided by the registers. We will also discuss about new regulations, how and if some new regulation, mainly the eIDAS regulation from the European Commission, will impact on the activity of the business register, but also probably would help to create new services that could enhance the performance of the business register again. And finally, we will discuss about, with Kevin, how technology is giving the possibility to transform the service provided by the business registers. We will start with a German speaker, Johannes Hushahn, more or less. The name is like this. Johannes is director of the German Federal Chamber of Notaries and has been a lawyer on corporate law and real estate. And Johannes is going to talk about electronic ID and within the eIDAS regulation. So, Johannes, please, the floor is yours.
Thanks. Good morning, ladies and gentlemen. Thank you, Vito, for the kind introduction. Yesterday, we've heard already about how the digitalization of business registers advances, and also the results of the International Business Registers report was quite impressive to me, and I think it speaks a clear language. Registration by electronic means is increasing, as is correspondingly identification through eIDs as well. What legal impact the eIDAS regulation has on this, I will try to endeavor to explain in the next and following 15 minutes. And I hope that this works. Magdalena has some experience from yesterday. Shall I wave? Shall I not wave? Shall I wave? Shall I try? Yeah? Oh, waving is not a good idea. Oh, here we go. Very well. Oh, yeah. So I'll try to give you a general overview on the eIDAS regulation first. Then I will go into the scope of the regulation, always for lawyers and notaries as well. That's very important to know what's actually the scope of a legal act. Then I will go a bit more in depth into the electronic identification provisions of the eIDAS regulation and provide you, hopefully, with a sensible conclusion at the end. Very well. Yes, the eIDAS regulation 910 out of 214 contains, apart from general provisions, mainly two parts. First part is the part on electronic identification, eIDs. Second part is the one about trust services, which also is a very interesting topic, however, not part of my presentation today. I will endeavor to explain you a bit more about the eID provisions in the regulation. Within the provisions on eIDs in the eIDAS regulation, the most important and central provision certainly is Article 6 on mutual recognition, which is, for instance, also referred to now in the general approach of the Council on the SUP Directive on single-member companies. Also an interesting fact, just to mention it once, and I won't go into the details because that might be too boring, even here. There are 26 implementing acts and one delegated act to be issued by the Commission. They're drafted at the moment, at least some of them, by an expert group, which will further give detail to the sometimes a bit more general provisions within the regulation itself. The eIDAS regulation, as any regulation, any legal act, has a certain scope. Here the scope is laid down in Article 2. And I know it's bad practice, but I would like to quote the relevant provisions in full here because the precise wording is as interesting as it is important. So let's have a look on Article 2, paragraph 3. You can read it also here on the presentation. It says, this regulation does not affect national or union law related to the conclusion and validity of contracts or other legal or procedural obligations relating to form. And this is further illustrated by recital 21. It says, this regulation should not cover aspects related to the conclusion and validity of contracts or other legal obligations, where there are requirements as regards form laid down by national or union law. And in addition, it should not affect national form requirements pertaining to public registers, in particular commercial and land registers. Hence, if there are national form requirements, like, for instance, notarial authentication, they cannot be overruled by the eIDAS regulation. That explains and is further underlined, for instance, by the already mentioned EU Council's general approach on the SUP directive, which expressly applies or makes use of the eIDAS regulation by referring to it in its Article 14b. That would not be necessary if it were clear from the very beginning that eIDAS regulation could be applied in that respect. The reason for this scope is that there are fundamental differences, clearly, between different registers, also still between different registers in Europe. Yesterday, I had the impression that some are of the opinion that third parties are never concerned, really, by this difference. I think that's not true. Where there's public faith in a register, you get what you are entitled to. Where there's no public faith in the register, you might get damages if you're lucky. For me, that's a weaker claim because you do not get what you actually want to get, and it might have serious implications in case of insolvency as well. So let's move on and let me switch to the main provisions on electronic identification then. Here they are. As I mentioned before, the core provision is Article 6 on mutual recognition. It has certain prerequisites under which eIDs issued by other countries have to be recognized. One of the first is not mentioned here on the slide. It's important that the electronic identification is already allowed under national law or union law to access a public service in a certain or in the country where the other eID shall be recognized. Only then, but in any case then, any notified eID, so notified by another state with the same assurance level than the one required by the recognizing member state, has to be acknowledged, has to be recognized. eIDs in this respect are only really relevant regarding natural persons because, and that is a very important aspect for commercial registers, of course, they give no proof of existence or representation of a company. Other important provisions are laid down in Articles 7 to 9 especially on notification because, as I've mentioned before, the eID that is supposed to be recognized by another state has to be notified first by the issuing state to the European Commission. And under which circumstances this notification happens is laid down in Articles 7 to 9. You have some provisions on the eligibility of eIDs, so under which conditions an eID is at all eligible for notification. Certain preconditions for this have to be met, for instance. You have a very general but still provision in Article 8 on criteria for different assurance levels. Level low, substantial, and high, they are called there. And you have the actual provision on the notification procedure laid down in Article 9, stating, for instance, which information actually has to be notified and obliging the Commission to issuing a list of notified and hence recognizable eIDs. There are some other provisions on eIDs as well in this respect and context, which might not be of such great importance for the registers themselves, because normally they come after the registration or after the recognition of an eID. Security breach in Article 10, member states or the member states have to suspend and or revoke the cross-border authentication if there is a security breach, a known one in an issued eID. That's pretty clear. There are some provisions on liability and also, and mainly mostly important in this respect, procedurally, on cooperation and interoperability in Article 12, so cooperation between member states, of course. So I promised Vito not to talk longer than 15 minutes, and that's why I already want to come to my conclusion here. So let me just recap a bit of the main aspects I have just tried to explain to you. Most important to me is the scope. The eIDAS regulation does not affect legal or procedural obligations relating to form, and that's why national form requirements of public registers are not affected. That does not mean, of course, that eIDs and the eIDAS regulations have no effect on public registers whatsoever, but where there are national form requirements, they cannot be overruled by eIDAS regulation. That's the important message here. Having said that, that is only true as long as the national or European legislator does not expressly apply the eIDAS regulation in this respect, of course, As I've mentioned before, as you can see in the SUP directive, where that is expressly the case concerning online foundation of these single-member companies. That might be also a warning to those countries with certain form requirements, those countries which are of the opinion that those form requirements are necessary and important for the public faith in the registers, to make sure that this is not the case. Otherwise, there might be a split system within the registers, and you might have different input quality of data, which might not, in the end, really justify the public faith in total anymore. Anyhow, as I've said before, any notified ID with the same assurance level as the eID of the recognizing member state have to be recognized. That might be a huge impact if eIDs get used more, because in principle, every eID of every single member state then, in the end, has to be recognized by other member states, and you also need, of course, the technical requirements necessary in order to achieve that. And last but not least, really relevant are these provisions on eIDs only for natural persons, because, as I've mentioned, they do not give proof of existence or representation of a company. Ladies and gentlemen, I thank you very much for your attention.